Great. As people are coming in, I'm just going to start off with a few brief housekeeping remarks before we jump into the material. So just to start off, my name is Claire Ladd, and I'm the Programs and Services Manager at the Massachusetts Nonprofit Network, MNN. Thanks so much for joining us today. And just a few quick housekeeping items before we dig in. The recording and the slides from today's program will be emailed to you following the webinar, so please keep an eye out for that. And during the webinar, if you have any questions for the presenters, I encourage you to submit those via the Q&A function. The presenters will keep an eye on those and answer them as time allows. If you have any other logistical questions or questions for me, feel free to drop those in the chat anytime, and I will respond. I also just want to give a little background about us here at MNN. Our three goals are to strengthen the nonprofit sector through advocacy, public awareness, and capacity building services. We offer regular webinars in partnership with our affiliate members, like this one, as part of these capacity building efforts. So please stay tuned for future topics and let us know if there's any topics you'd like to see. Our efforts are made possible by our more than 600 member organizations. So thank you to all of those who are members. And if you have not yet joined, but would like to take advantage of all of our member benefits, please visit massnonprofitnet.org/join to find out more. All right, today's webinar is titled Traps for the Unwary Nonprofit, and the presenters are Kathleen Berney, Rich Loftus, and Sarah Ruter of Hirsch Roberts Weinstein LLP. So I will hand it over to the presenters to get started.
Hey everyone, welcome to our presentation. Thanks for being here. My name's Rich Loftus. I'm a partner at Hirsch Roberts Weinstein, and we're really glad to be here as well. We're excited to talk about some of our favorite topics. They're our favorites, so they don't have to be your favorites. But I just wanted to say thanks for all that you guys do. We work with a lot of nonprofits in a bunch of different aspects, here in the Commonwealth, human services, health, lots of different ones. So, we understand, some of the challenges you guys face and some of the great work that you do. And we're really proud to be able to work with our nonprofit clients and help them in some small way on their important mission. So thanks again for all you do. And let's dive right in. Next slide, please. So this is just a quick disclaimer here. This is for educational purposes and shouldn't be taken as pure legal advice. As lawyers, we have to get something like this in there. I'm sure you expected it. Next slide, please. All right, so here's our ambitious agenda for our 1 hour together. But we do want to encourage you to submit questions, as Claire mentioned, in the Q&A function, and we'll do our best to answer them either as we go or at the end. But first, we're going to talk about wage and hour compliance, which is one of my favorite topics. Then Sarah is going to talk about some multi-state compliance issues. Kathleen will field some issues about handbook policies. Then we'll switch back to me on managing reductions in force. Then I believe it is Kathleen again in avoiding errors in interactive dialogue. And then finally, Sarah is going to bring us home with I-9 challenges. So next slide, please. As I just mentioned, wage and hour compliance is one of the things that I focus my practice on. And it's a particularly important aspect of employment law because of the potential penalties that can come with it. And it's a strict liability statutes. So, the requirements of paying people correctly and on time don't really care if you tried your best or if you really meant well, you did something in good faith. It can still be problematic for you if you do it wrong. So next slide, please. One of the big traps that we see is misclassification of folks as as something other than an employee when really they are actually, in reality, at least in the eyes of the law, an employee and have to be treated as such. So one of the big ones we see is treating people who are actually employees under the definition of the law as independent contractors. In Massachusetts, it's very difficult to properly classify somebody as an independent contractor if they're an integral part of your operation. If they're helping you to carry out your business, then they should probably be an employee. Misclassification of employees as exempt. We'll talk in a little bit about the specifics of that, but if all of your employees are treated as salary exempt and don't get overtime, you've probably got some that need to be changed to hourly employees. As nonprofits, you may have interns or volunteers. It's permissible to have interns and volunteers as nonprofits, but you need to make sure that you are properly classifying them as such. Typically, you do not want to have interns or volunteers displacing a full-time employee role. And then failing to pay on time. In Massachusetts, you need to pay current employees within 6 days of the end of the pay period that the wages are earned in. So if you don't do that, that can be quite problematic. And we encourage you to make sure that you understand these sort of ongoing obligations. Talk to your payroll company, make sure that you understand them. Feel free to consult with employment counsel. We can help you walk through some of these issues with you as well. Next slide, please. So as I previewed, one of the big things that we see is treatment of employees who are actually non-exempt as exempt employees. And when I say exempt, I mean exempt from the overtime laws. And so the non-exempt employees are paid by the hour. They must track the hours worked. They're eligible for overtime if they work more than 40 hours, and they must get at least minimum wage of $15 per hour. And I just noticed a typo here because in the exempt column, the guaranteed salary that you need to pay is actually $684 a week. It was raised by regulation several months ago. However, it was blocked by a court. So the 684 is still in effect. And here's the really important thing. In order to be properly classified as exempt, you must have exempt duties. So, for example, an exempt professional like a teacher or a doctor or a lawyer, an exempt administrative employee like your head of HR or your head of marketing. Some sorts of coordinators can qualify here too. And then your executive exemptions, which are folks like managers, the CEO, the executive director, all of those types of positions will qualify as exempt executives. So in order to properly be exempt, you have to be paid that guaranteed salary of $684 a week, and you have to have those exempt duties. Next slide, please. All right, so as I mentioned before, you have to pay current employees within 6 days of the end of the pay period in which the wages are earned. However, if you terminate somebody involuntarily, then you must pay them in full for all of their earned wages, and that includes earned but unused vacation time on the day of termination. So if you're not able to do that, then I would strongly encourage you to either suspend them with or without pay. With pay is a little bit less legally risky, but without pay is better than terminating them without paying them in full on their last day. The reason being, if you pay even 1 day late, the Massachusetts Supreme Judicial Court, in all of its wisdom, has said you now owe the employee triple damages on those unpaid wages. And yes, the payment of the wages 1 day late is 1/3 of those triple damages, but you're still going to have to pay the other 2/3 of it. And you need to pay their attorney's fees. So if they hire an attorney and sue you, you need to pay for all of the fees they incur in order to recover those wages from you. And as I mentioned earlier, it's a strict liability statute. There is no good faith defense to it. So that means that whether or not you intend to run afoul of the law, any violation of these wage laws will result in triple damages and attorney's fees. So it's really important to understand and comply with them. Next slide, please. And then to wrap up our whirlwind tour of problems that we see with wage and hour issues in Massachusetts, especially with nonprofits, just wanted to hit on two quick things. One, If you have remote workers, make sure that you have an effective system in place to track their time, right? If you are just assuming that they're working certain hours or you're not effectively tracking their time, that could be quite problematic. If, for example, they get upset with you because maybe they let go or they get passed up for a promotion, and then suddenly they're talking to a lawyer and saying, hey, I've actually worked 50 hours a week most weeks, but they've only paid me for 40, and I should have been getting 10 hours of overtime every week. We've seen these cases, we've defended against these cases, but it's a lot better to prevent it on the front end. So make sure you have an effective time management system. And then lunch breaks. I know it can be a challenge sometimes, especially in, health and human services or direct care staff, to be able to grant your employees a lunch break of half an hour for every 6 hours worked. And they must be able to leave the premises. However, it is a legal requirement. There are ways to get them to waive their ability to take a break, in which case they need to be paid for that time. But really, it's supposed to be voluntary on their end. So if you're having issues with giving folks lunch breaks, feel free to reach out and we can help walk you through it. So thank you for sticking with me through that whirlwind tour, as I mentioned, and I'm going to turn it over to Sarah.
Hi, everybody. Thanks for being here today. Just want to take a few minutes to talk about multi-state employment issues as they may impact you. As everyone is aware, many people since the pandemic have learned that it actually does work in some cases to have employees working remotely. And it may be the case that you have employees that work remote part of the time. They live in a different state than their office is in. They work completely remotely. And so it's important for you to know that if you have remote employees or employees that work in different states, you may have different requirements that you need to follow, even if you are a nonprofit based in Massachusetts. So next slide, please. Just want to talk about a couple of the big ones that can differ by state. First, riffing off of Rich's wage and hour, there are typically overtime means you're working over 40 hours in a week. Most states and the federal law define overtime as 40 hours during any given week, and at that point you have to start paying time and a half or overtime. But there are some states where you will have to pay where you'll have to pay overtime if you go, there's a daily rate. So if you go over 8 hours in a day, if somebody works over 8 hours in a day and they're non-exempt, in California, in Alaska, in Colorado, in Nevada, all of those states have a daily overtime requirement. So they might not have met their 40-hour threshold, but if they meet their 8-hour, then anything after the 8th hour has to be paid overtime. In Kentucky, they have a consecutive day requirement. So it's the seventh consecutive day of a 7-day work week. At that point, the seventh, that anything happening on the 7th day, if they work consecutively, is overtime. Those are just a couple examples. Next, protected classes. Most states and the federal government, EEOC, have many similar protected classes, such as race, gender, sexual orientation, religion, and things like that. But there are some states or cities that have adopted even more protected classes. Many states now have passed a Crown Act, which is an act that protects people on the basis of natural or protective hairstyles that are typically associated with race. Massachusetts has a law like this. In New York City, they passed an ordinance saying that height and weight are protected classes. So you can't discriminate based on those two things. In the state of Washington, you can't discriminate against someone based on caste or social status. And in Iowa, you cannot discriminate against someone because they have to take a drunk driver's rehab class. So there's all kinds of different things that you may or may not be subject to. And typically, you're not thinking about things like caste or height or weight, but you might have to if you've got an employee in that state. Moving on to sick leave accrual and usage. Every state is a little bit different. Some states don't have any sick leave, and some have very specific requirements for it. Also paid family and medical leave. This is something that's trending. More and more states are passing paid leave laws. And so I think sometimes people assume that because you're a Massachusetts company, everybody in the company is entitled to Massachusetts PFML, or paid family and medical leave. And that is not the case. You can choose to adopt a more lenient or more generous leave policy, but you are not required to pay a fully remote employee who works in Texas Massachusetts PFML, even if your company is in Massachusetts. Also required breaks. Rich talked about that briefly. Sometimes states have different requirements for what you have to allow people to do. And then pay transparency, another trend. This is really when people ask about their salary, or if people are applying for jobs, what are the requirements that you have in that state to disclose things like the range of salaries or the benefits and things like that. So you want to think critically about what policies you want to apply to everyone across the company, and what policies that you want to customize by location. So something like jury duty leave, you could decide, you know what, I'm going to just take the state that has the most generous jury duty leave and apply it to everybody, because that's easiest for us to do. But that might cause some, especially in a nonprofit where things are tight anyway, might cause some administrative headaches, or it might cause you to be missing people more than you actually are legally required to. So that is a decision that you have to make as a company. We can, of course, help you, advise you on those things. But you can always be more generous than what the state allows. You just have to make sure that you're not being less generous, and you're not foregoing some right that the employee in that particular state has. Also, don't forget cities and counties. Some cities and counties are not waiting for their states to pass particular laws, and they're going ahead and saying, you know what, we as a city believe that there should be paid family and medical leave, or we as a city are adopting a domestic violence leave, even though our state hasn't passed it. So, for example, in Illinois, there's a paid leave act. It's paid leave for any reason. But there's a separate version of it in Cook County, Illinois, and there's an even more generous version of it in Chicago. So it's whatever gives the employee the best deal. If they're in Chicago, they're going to get the Chicago policy. But if they're in Cook County, even if they're not in Chicago, they're going to get the Cook County policy. This can be confusing, so please don't hesitate to reach out, because we deal with these kinds of things all the time, and it can be tricky. Next slide. What you want to ask yourself is, where are your employees? And in order to determine where somebody is considered to be an employee, where is the work being performed? I know in Massachusetts, there are a number of people that live in New Hampshire, but primarily work out of a Massachusetts office, or same with Rhode Island. And if that's the case, if they're hybrid, or they're working out of the Massachusetts office, even if they're working from home 2 or 3 days a week, they're still considered to be a Massachusetts employee. But if it's somebody whose work is completely remote and they are working in that state all the time, then they're going to have to be classified in that state. If you have questions about that, let us know. It's typically where unemployment, whatever your payroll system is using for unemployment or other withholdings, is a guide to where that person is considered to be an employee. You have to also decide what state's law applies in a particular situation, and does your employee handbook address these issues? Next slide. Here's just an example of 3 states' policy distribution requirements. So here's 3 states. These are 3 of the most employee-friendly states. And just all of these requirements for policies that have to be distributed to all of your employees. So for example, in New York, you have to have a sexual harassment policy that's distributed to all employees, and you have to be able to show that you did that. In New York, pay practices, you have to not only follow the law, but you have to tell employees, like, this is how often you're getting paid, And this is our work week. This is our work week. It's defined as X and Y. In New York, you also have to have an acknowledgement of electronic monitoring. This is, again, another trending thing that more states are passing. But if you have employees in New York, it's really important that you use the exact language that they have recommended. And you need to be able to show that an acknowledgement with that language, that an employee understands that they're going to potentially be electronically monitored on their phones or their computers or whatever other systems you're using. So this is a lot to keep track of. What's the best way to keep track of and accomplish all of these requirements for different states? And that is going to be an employee handbook. And for that, I'm going to turn you over to Kathleen.
Thank you, Sarah. Good morning, everybody. I'm so pleased to be here. Like Rich said at the outset, we just are so honored to work with nonprofits and to assist you in your mission as employment lawyers. So handbook policies, springboarding off of Sarah's points about multi-state, I'll home in on handbooks, including the question about whether you should have one, which the answer you might not be surprised to hear is that I recommend that you do. And most importantly, why we think that you should. Next slide. What about employee handbooks? Here are the top 3 reasons that I recommend you have a handbook, almost irrespective of your size. Now, there are certain laws that only apply when you hit a certain size, but for the most part, we'll talk about why it's a really good thing to have. First, a handbook puts into action your company's policies, your company's philosophies and values. There is, and the exercise of determining those and setting them down onto paper is just such an important, wonderful way to align what you do on a daily basis with your mission. Secondly, your handbook is a way of unifying your company. It sets a level playing field. And we as employment lawyers, of course, see a lot of the problems. And what I find is that in the absence of policies and procedures, what sometimes can happen is that an employee with the best of intentions can make up their own policies, or they do their best to act the way that they think that they should be, and what the policies they think should be. And they share sometimes this information with each other. Perhaps they might be following your lead as a nonprofit leader, but your role might be very different than theirs. You might have different hours, different job duties. So we don't want to leave, bottom line, employees guessing, right? We want fair, equitable, value-imbued policies and guidelines for your employees. And thirdly, as an employment lawyer, again, who defends many claims of discrimination, harassment, et cetera, it is essential if you are before an administrative agency where an employee has accused you or a former employee of discrimination, retaliation, harassment, it's usually Exhibit A to any position statement that we submit to an agency or to a court. So it's really important that we have that. And also, of course, it sends a message to your team, to your people, that, hey, this really matters to us. These policies matter, and we want you to know they're there, and we want you to follow them. Next slide, please. One handbook to rule them all. So this is a question that I think, Sarah hit on this just a moment ago. And there's no one answer for this question about how you structure a handbook. You're going to want to look globally at where all your employees reside and work. If they all live in Massachusetts, it's simple. You have a Massachusetts focused handbook. But if you do, for example, if you are a New England centric organization with Massachusetts, Rhode Island, Connecticut, et cetera, then you really are going to have to decide, well, am I going to have, like Sarah said, certain policies that go to the most generous state, the most generous state's jury duty policy. But then again, even if you take that viewpoint, there's still certain ordinances, state requirements where specific language is needed. Something as important, as Sarah was saying, what protected classes you will include in your anti-discrimination policy. If you're in Iowa, who knew, but drunk driving is a protected class. So if you were to do the most generous inclusiveness and you have an Iowa employee, you would have to add that particular protected class to your policy. The other way to do it, of course, would just be to have, if you're Massachusetts based, a Massachusetts policy handbook, and then addenda for the states in which each of your employees live and work. And don't forget, of course, these ordinances and city rules when they apply. Next slide, please. Most common reasons why your handbook might be featured in a legal claim. Well, we all know on this webinar that at-will employment means that you as an employer can terminate an employee at any time for any reason or no reason at all, and the employee themselves can similarly leave for any reason or some reason or no reason at all. But what we see as employment lawyers defending wrongful termination claims are claims of that an employer failed to follow its handbook, failed to follow its offer letter. And part of that argument is the assertion that that handbook was a contract, that that offer letter was a contract. Something simple like a policy that says, typically an employer will provide a written warning before proceeding to termination. We see instances where a claim will be filed that, oh, you broke that contract. So when you have a handbook, and this should be in your offer letters too, the first page in bold and underline, and there are Massachusetts courts that say that you should have certain language there, but will say this handbook is not a contract. This, then we as the employer can make changes at any time. So keep that in mind, have a handbook, have language around at-will employment. It's very helpful if you find yourself facing those wrongful termination claims. Rich already talked to you about wage and hour claims and how they're strict liability. So it doesn't matter if you didn't mean to do something wrong. And it's very important for you to think about having a safe harbor policy in your handbook, which says, hey, employee, if you think that there were any improper deductions taken from your pay, here's who you should go to. And we take those complaints seriously. We won't retaliate against you for bringing them, and we'll address your issue right away. NLRA issues, that's the National Labor Relations Act. That's a complicated area of the law. I think what's important for you to know is that, and you probably already know this, is that even if you're a non-union nonprofit, which I know most of you are, your employees are still protected by Section 7 of the NLRA, which allows them to talk about and do certain things, engage in concerted activities about the terms and conditions of their employment. And your policies can't violate those rights. For example, we all know this now in Massachusetts and across the country these days with pay transparency laws and equal pay laws, but you can't prohibit an employee for talking about their salary, and you can't have a policy that says that. Social media policies that prohibit an employee from saying anything about your company would likely violate the NLRA. So there are some nuances there that you'll want to think about, and confidentiality also. Of course, trade secrets and stuff are different, but an employee has the right to talk about certain parts of their jobs with others. And discrimination, Sarah talked about this a little bit already, and I touched on it as well. Your discrimination claim will be Exhibit A to any submission that a lawyer makes on your behalf, defending against those claims. And it's just really important to have the pathway for employees to know, who do I go to if I feel like I'm being discriminated against or harassed? And Massachusetts has a model policy. It's available on the Attorney General's website, and that's a good starting point if you don't have one. Next slide, please. Can I just use the same templates for everyone? I think Sarah did a really good job of giving you the big answer of no, because particularly if you have work in a multi-state environment, we have these different protected classes. Something like sick leave is a really great example. If you have a Massachusetts employee, you know that they earn 1 hour for every 30 hours worked, up to 40 a year. You're not required to pay it out at termination. Rhode Island employees have a different policy, and as does New Hampshire. So, or laws, I mean. So your policy is either going to provide exactly what that person in that state is entitled to, or it's going to use the most generous state's policy, in this case, Massachusetts. Pay transparency laws. We have different requirements about salary disclosure. We have one coming up in Massachusetts in October. The timeframes will vary as to when you as an employer have to get back to the employee if they ask about what the pay range for their position is. And that'll vary state to state. Background check policies, we have the ban the box 151A policy in Massachusetts that tells employers certain types of crimes that they can't consider, or certain periods of time that have elapsed since the crime was committed, in terms of whether they choose to hire somebody or not. So the short answer is that you really do need to look at where does everybody live, what state or city or ordinances apply, and figure out from there what your handbook will look like. I just want to emphasize that this really can be, I see some really good handbooks, but really uniquely attuned and created to use the language of an organization and to reflect the values. And it could be a group exercise with leadership for you to take on if you don't have one as of yet. Next slide, please. And with that, I'm going to turn it over to Rich, who will talk to you about RIFs.
Hey again, everyone. Unfortunately, one reality of operating an organization that's less fun to talk about, but is sometimes necessary, is a reduction in force. And although, it's never fun to have to restructure or lay people off, it is sometimes necessary to do it. And so I want to talk a little bit to you about how to do it in a humane and least legally risky way. So next slide, please. The most important thing about a layoff is to plan it carefully and document the steps that you have taken to implement that plan. The identification of the operational reasons why you need to do the reduction force or restructuring is really important. So, you need to think about, okay, here are the challenges our organization is facing, whether it be, potential loss of federal funding, could be a change in the way that the state administers certain grants, it could be just a change in the needs of the community that you're serving. So think about why you need to make that change and then document that. Create a literal document that says, okay, this is why we need to make a change, and identify the goals of that change. So, we're going to have a budget shortfall of $1 million next year. We need to cut payroll by X amount in order to help cover that budget shortfall. So once you've done that, then you need to think about who you're choosing for the layoff. And let's talk a little bit more about that on the next slide. So here are some of the steps that you might want to think about as the process unfolds. This is not a one-size-fit-all solution here. They don't apply in all instances, but some of the steps really do require you to carry them out. Like, that's documenting the business reasons or the organizational or operational reasons for the RIF, selecting the decision makers, people who are going to be making the choices about who is going to be selected for the reduction force and who is not. Once you've had those decision makers in place and you have a clear goal of what needs to be done in order to meet the goals of the restructuring or reduction in force. Then the decision makers will sit down and decide, how are we going to implement this reduction in force? Who are we going to choose? And it's really, really, really important to have them document the reasons why they are picking certain people over others, right? Um, Sometimes people will shoot from the hip a little bit in choosing folks for the reduction in force, but I really encourage you to have them sit down and write down why they've chosen certain people over others. And if they can't articulate a reason why they've chosen one person over another, then perhaps a different choice is in order. And it should be a business reason, an operational reason, right? Like, this person's performance has been great. We want to keep them. This person's performance has been subpar. They're actually on a performance improvement plan. They're going to be selected for the reduction in force. Or redundancy, right? We have 3 people doing this same role. We only have a need for 2 people doing it. So this person has been selected for the reduction in force because they're the least senior. They have the least amount of experience, or their educational background doesn't fit quite with what we're doing. It just needs to be a legitimate reason why you're documenting this. Then let's go to the next slide, because I really want to emphasize this. We get a lot of pushback from managers sometimes who do not want to take the time to justify the choices that they've made in who they're selecting and who they're not. But I can't emphasize enough that it's worth more than its weight in gold. A 1 or 2 page justification form is going to be priceless in defending against any accusation that this person was chosen for improper reasons, right? Because of their age or their race or their gender or their sexual orientation, etc. Or whether, they brought up something about not being paid their wages correctly, or they, mentioned, they reported what they thought was sexual harassment of another employee, right? You need to be able to document the reasons for that justification. And next slide, please. This is something I really want to emphasize as well. HR is the gatekeeper of fairness. It's HR's job under these circumstances to say, okay, the reasons that the manager has given for selecting this person over this person ring a little hollow to me. They actually don't seem to make sense under the circumstance, or they're applying inconsistent reasoning, right? Like, in one instance, they're saying the person with more seniority should stay, and then in the other instance, they're saying the person who gets paid less should stay, right? You want to be consistent in your application of reasons why you're keeping somebody to the extent you can, right? Sometimes there will be different reasons, right? Someone's skill set might be the reason you keep them in one instance, and somebody's performance might be in another instance, but you wouldn't want to say skill set's really important in one instance, but then in the other say, oh, it doesn't matter at all, right? So you want to watch out for that stuff. And HR is the folks who can help, or management, upper management, looking over the decision-making processes of the folks who are selecting the individuals for a layoff. It is really important to have that second layer of review, just to make sure that the choices that they're making actually make sense. Next slide, please. So one thing that is also really important to do is to do some demographics analysis, both of what your workforce looks like, both before and after the proposed RIF, right? By RIF, I mean reduction in force. The one thing that you can see happen from time to time is, you have this decision-making process, but then you look at what your workforce is going to look like both before and after, and you notice, hey, we're letting go, 90% of the folks over 60 within our company in this reduction in force, and we're keeping a lot of folks under 30. That can be problematic in terms of claims from people who are laid off in that, because it's what's called disparate impact theory, and It's, hey, you might have been trying to approach this from a neutral way, but it had a disparate impact on folks in a particular protected class. And it could also be evidence of some sort of bias creeping into the decision making as well. So do take a look at what your demographics will look like before and after. And if there's, a significant burden upon a particular protected class or, the particular group of employees demographically, then think about what the reason behind that might be. Next slide, please. So I would encourage you in a situation of reduction in force, if you have the means, to consider severance in order to give the employees a soft landing. Not only do they appreciate getting the offer of severance as it helps them to move on to find another job, but if you tie it to signing a severance agreement, which contains a release of claims, then you can protect your organization as well. So, offering some severance, and, there's different ways to approach it, right? It could be providing a certain amount of severance for years of service, or, just whatever your circumstances might be, in exchange for signing a severance agreement can be a really helpful thing for everybody involved, right? The employee who's being let go and for your organization. And next slide, please. And then I just want to emphasize this again. I know I did at the beginning of this segment, but you got to document things. You need to document the reasons for the RIF and the reasons you've chosen certain people for the RIF. That would be the bare minimum in my mind of what you need to do in order to provide those justifications if you're ever challenged. It might all be well and good in your head, right? That you've thought all these things through. You understand there's a clear reason for the reduction in force in your head. You've got good reasons from discussions with managers why certain people are being included and others are not. But if you didn't document it, it might as well never have happened. Courts, administrative agencies, anybody who is looking at a challenge to your decision-making process is going to expect that there's going to be documentation of why you had the RIF and why you've chosen certain people for the RIF. So make sure that you're able to meet that expectation. You don't have to write an encyclopedia, but you do need to have some documentation. So thank you. And I'm going to turn it back over to Kathleen.
Thanks, Rich. Our next topic is avoiding errors in the interactive dialogue regarding employees' accommodation requests. Next slide, please. Massachusetts law and the Americans with Disabilities Act makes it very clear that employers must provide a qualified disabled person with a reasonable accommodation that enables them to perform the essential functions of their job. And there are steps in this process. First, it is the employee's job to inform the employer, oftentimes their manager, but it could be anyone in management really, that they have a disability and that they need an accommodation to perform their job. The law tells us that there aren't any magic words that the employee must say. It does not have to be in writing. It could be just verbal. And then second, once the employer is on notice of the need or the request for an accommodation, the employee and the employer together have an obligation to engage in the interactive dialogue or the interactive process. It's like a dance. Both parties have to participate in order to make this dance. And then third, the dance begins, the communication begins, and it doesn't have to be a one-step communication process. In fact, in most cases, it won't be unless it's pretty simple and straightforward. There will be some kind of meeting, some kind of discussion, and then a going away and a returning to a meeting of the parties to decide what could work here based on what the employee wants, what the employer can or cannot provide, and what the disability itself is. And then once the reasonable accommodation is reached, if reached, then it will be implemented. Next slide, please. So the emphasis here is on reasonable accommodation. What is a reasonable accommodation? And what that is something very simply that will allow the employee to perform their job duties, the essential job duties in particular. And this is important for employers to know, is that you don't have to grant the requested accommodation that the employee asks you for. It may not be reasonable, or perhaps it really is. But what you are required to do as the employer and the employee is engage in this dance, this interactive dialogue. Next step, please. Next slide, please. So let's talk about when an employer is not required to grant an accommodation. That would be in a situation where the accommodation request would result in undue hardship for the employer. And the law defines undue hardship, the case law defines it as a significant difficulty or expense for an employer. And because those terms are so relative, it really will matter how large or small your nonprofit is when determining whether something would actually be an undue hardship. $1,000 accommodation, something that would cost $1,000 for a corporation of thousands would be weighed differently than a nonprofit of 6 or 7. So all of that will matter in terms of the type of nonprofit you are, the size of your nonprofit. And then another reason that you could deny an employee's requested accommodation is if that would cause a direct threat to the safety of the employee, to others, the employee themselves, to others in the organization, or to the property. For example, not nonprofits necessarily, but if a construction company, if somebody who drives a forklift is having episodes of blacking out, and they ask for an accommodation to only work certain hours in the day, you may have to deny them being able to work at all, because that could be a threat to everybody's safety on the job site. Next slide, please. Unreasonable accommodation requests. Here's what the case law and legal guidance tells us about what some examples of unreasonable requests are. If the employee asks that an essential function of their job be eliminated, if, for example, your nonprofit if you have a budget coordinator role, and the individual unfortunately suffers some sort of traumatic brain injury, and they're no longer able to add up numbers and not able to do any budgeting, eliminating budgeting from a budgeting coordinator's job duties would be an elimination of an essential function. So that wouldn't be reasonable. Now, that's not to say that the dialogue stops there, but these are just examples of what would be or could be unreasonable requests. Lowering uniformly applied standards. For example, if your organization has some sort of productivity goals every month, or a sales organization, sales folks have to meet certain targets, lowering those targets is not required under the law. This is a very common one we see, an indefinite leave of absence request, where for whatever the reason may be, the person is very ill and they just don't know when they can return, even after they've gotten perhaps 20 weeks of mass PFML. An employer is not required to keep a job open indefinitely ongoing for an employee, nor is hiring 2 people to perform the jobs of that one particular individual. Next slide, please. If you walk away from this portion of the webinar about reasonable accommodations, taking anything with you, one thing I would say as a nonprofit is that your duty is to engage in the interactive dialogue And just remember, communicate, communicate, communicate. You almost can't communicate enough when it comes to the interactive dialogue. The failure to accommodate claim is the most common one that is seen at the MCAD. And it usually goes along with its cousin, disability discrimination. But it's really easy to bring a failure to accommodate claim if an employer doesn't sit down and simply ignores the employee's request, no matter how unreasonable they are. You still have to engage in a dialogue with them, even if you know, based on what they're asking you, that it's absolutely going to be a flat out no. You still need to sit down and engage in that dialogue with them. So just keep that in mind, no matter what you walk away with today. Next slide, please. So some key takeaways. Again, communicate, communicate, communicate. Rich already said this in the RIF context, and I'll repeat it here. You also need to document what each of those 4 steps I talked about. One common thing that I do see, and I know Sarah and Rich see this too, when we defend discrimination, disability discrimination, and failure to accommodate claims at the administrative agencies or in courts, is that a lot of times there actually have been accommodations granted, but they weren't documented. And it doesn't have to be fancy. A simple email to the employee: thanks for meeting with me today. As we discussed, for the next 3 weeks, because they don't have to be ongoing permanent accommodations, they can be temporary. We agree that you can start at 8 a.m. instead of 8:30 and leave at 3:30 instead of 4. Whatever the accommodation is, get it in writing. If it's something where you don't have enough information, you're allowed to ask, and you should ask. Sometimes the accommodation request is simple. Hey, my back is bothering me. I have a desk job. I'd really like a lumbar support. Sure, we can get you that. Send an email. Thank you. It'll be arriving on Thursday. But perhaps it's more complicated, and you don't really know what the employee's disability might be and what you can give them. You can ask for the medical documentation, and the employee is required to provide that. And if they don't provide that, that can be a way for an employer to win one of these disability discrimination claims. But really, we all want our employees to be able to do their jobs, and we want to reasonably accommodate them when we can. So with that, I will turn this over to Sarah to take us home with I-9 compliance.
We have saved the most interesting and best topic for last, I-9s. As we live and work in this evolving world where legal documentation of your ability to work in the United States is becoming a topic of everyday conversation, it is really important for you as an employer to make sure that your I-9s are in order. So next slide, please. First, we want to talk about who needs to complete the Form I-9. And that is, I mean, really everybody does, but the employees complete Section 1. Trainees, interns, and clerks also need to do this. So if you have somebody that is in one of those categories, even if they're not technically a full-time employee all the time, you should still do an I-9 for them. The employers will complete Section 2. And then if it's a temp agency, if you're using a temp agency, that's usually considered to be the employer rather than the company that is using the services of the temporary worker. Independent contractor, as Rich talked about earlier, a true independent contractor doesn't need one, but as many people are misclassified as independent contractors and shouldn't be, it's better to err on the side of doing an I-9 if, and classifying them properly, if that is in any way in doubt. Next slide. When do we need to complete the Form I-9? So this one is actually a pretty tight turnaround. Employees need to complete their section on day 1 of their employment. And it is fine for an employee to, complete the section of the form on their own, but they cannot complete section 2 of the form on their own. That is one that the employer has to verify with documents and has to see it in person. But that they need to have theirs done on the first day. So you can send them the I-9 with their hiring materials if you want to put that step forward. Otherwise, you're going to have them come in on the first day and give them that form. Employers need to fill out section 2 within 3 days of somebody's hire. Again, not a lot of time, not even a week. So it's really a good thing to make this just part of your first day onboarding. If the employee is working for you on a very temporary basis, less than 3 days, then you have to do it on the first day. Next slide. We'll talk about the how now. And really, the I-9s should be done in person. You are going to be, as the employer, inspecting documents that they bring in from List A and List B. One is to show their identity. One is to show their authorization to work. And there's right on the I-9 form, there are lists of what qualifies as a List A and or a List B document. But you need to physically look at those documents and record the numbers or the details or the expiration dates on the I-9 as the employer yourself. I used to work for a nonprofit, and we had, we had 80 people starting on one day at a time. It was a summer program. And I could not myself do 80 I-9s in that first day or even first 3 days while everybody was getting trained. So if you have a large group of people coming on, you need to deputize somebody in your organization to help you with this, but you need to make sure that they're trained. So it should just be a few people that are doing this to maintain consistency. You shouldn't just pass it off to the manager of a department, but if you have multiple people in HR, or if you have somebody who's more of a generalist that can help do that, because that's going to make it a lot easier for you. There are some remote options if it's not possible to do it in person. E-Verify is the most famous and one that we recommend people use. It really does keep track of the documents well for you, and there are reasons to use it or not, which go beyond the scope of this particular webinar. But there's a lot of great information about E-Verify out there if that's something you're interested in doing. Next slide. Some common errors are missing deadlines, accepting unacceptable documents. So also incorrectly recording document information. So I just did an I-9 audit for a company that has hundreds of employees, and we decided to take 15 or 20 I-9s and just take a look at them as a sample size to see if there were, if they looked pretty good or if it looked like we needed to make some changes. Every single one of them had at least one error on them. But then once the company started using E-Verify, that was significantly reduced. So it's worth your time to do an I-9 audit. We're running out of time, so I'm just gonna I know we're gonna be sending you these slides, but just be aware that the process for this is important and having the correct information is important. If you have errors that you have failed to correct, that is a problem. So you can either if you find an error in an I-9, you can either have if the employee still works there, you can have the employee do a new I-9, or you can do a correction memo in order to make sure that the information is corrected. I think we're at 11 o'clock, so we should probably stop, but I don't know if anybody's got any lingering, burning questions.
Yeah, does anybody have any questions? All right, well, if not, we'll go ahead and wrap up for today. But, if anything comes up, if you wake up in the middle of the night and you're like, oh, I should have asked Rich, Kathleen, and Sarah this question, feel free to email us. Our email addresses are here on the screen, and I think they're going to be in the materials that Claire is going to share with you. So thanks again for being here, and it was great to be able to present to you.
Thank you so much to the presenters for sharing this great information. And yes, I will be sending out all the slides and contact info. So just keep an eye on your emails for that. And have a great rest of your day, everyone.
Thanks for having us, everybody.
Bye, everybody.
Thanks. Take care.
Take care.